Good afternoon, everyone. I, Chandan, on behalf of NEN and Wadhwani Foundation, would like to invite you all for this webinar and also introduce to our expert. Ms. Prity is Director at Tech Corp International Consultants Pty Limited, Singapore, and Partner at Tech Corp Legal LLP, New Delhi. Prity is an IP lawyer, registered patent attorney with the Patent Office. Tech Corp International Consultant is headquartered in Singapore and is a technology business consulting company that simplifies international business for their clients. They aim to build a dynamic and diverse portfolio of companies and ventures under Technocorp Group, www.technocorpgroup.com. The first venture, Technocorp Capital, represents a new concept conceived by amalgamation of business accelerators and incubators to provide strategic business services to bridge the path between ideas and prototypes. Technocorp Legal LLP is a full-spectrum technology and corporate legal consultancy and IP law firm. They serve startups, technology companies for tech transfer, industry associations, and startup business entrepreneurs. Here are a few reminders for the audience. You will all be on mute. You may ask questions by typing in the panel provided. Over to you, Ms. Prity.
Thank you, Chandan, for a warm welcome and good afternoon to everyone today. I would be discussing on importance of IPR for startups. The agenda for today's webinar would be what is IPR all about and relevance of intellectual property for startups, IPR strategies for startups, which includes clear research, technology watch, and competitive intelligence, and the IP myths which many entrepreneurs face in today's world. Firstly, what is intellectual property right all about? Intellectual property rights, it's an intangible asset. It's a work based on ideas, and it doesn't exist in physical world. Although IPRs of different types, it can be categorized, but they are not financial instruments like cash, bank accounts, bonds, and stocks. They can be valued and owned. It can be transferred by way of assignment deeds and can be monetized. Intellectual property is basically creation of mind. It's a thought process to create something new. It can be a brand name which you coin to start your venture. It can be a technology for which you want to file a patent application, and it is something new which nobody has thought till date. And for that, you need to protect it from infringers. It's unique to your business and it needs IP protection. If there's an idea, why not protect it? So great ideas definitely need protection. Protection from competitors, infringers from copying their intellect, creation, and the ideas which any third party can copy, so that he's diluting your brand name in that sense. From the investor's point of view, intellectual property is very important. It implements idea into practice to earn profits. When you seek protection, you can go a long way. And during evaluation, IP assets owned by the company play a very major role. Ideas can be protected by many types of IP. It depends from business to business what kind of IP is generated in your business, and it's very important to identify your IP, because if you don't identify what kind of IP your business is generating, so what kind of protection you are going to file for. So broadly, when we talk about today's generation or today's businesses, definitely brand name, everybody coins a brand name for their businesses so that a consumer can relate to their brand name. So it is protected by trademarks, and in trademarks also you have goods and service industry. When it's a good, you file for a trademark, it's known as T, and for the service industry, it's known as SM. And then we have patents. Patents we file for technology, which I'll be discussing further. And copyright is expression of information which is stamp of author's personality. So what is the advantage of having a protected intellectual property. Definitely, if you have your IP protected, it generates profit, and it's a sure shot success that your venture would be going long way. Now, as an entrepreneur or a startup, there are many questions. We get many questions when they start up and they have an idea like how to go about it, what to do about it. So there are so many questions like, why should I file for patents? Why should not I file for patents? Where should I file? What is an international patent? And when is the right time to file a patent? And who should I approach? I think by the end of the webinar, we will be able to answer these questions in detail. So intellectual property, as we discussed, is creation of mind. And is IP a business asset? Yes, IP is a business asset. Now, as I said, it's a form of intangible assets. It can be by way of copyright, can be patents, trademark, design registration, and it's basically when we protect IP, our consumers are able to categorize the business. They can identify your business. You can talk to your consumer when you have a protected IP by way of branding your business. As I said, IP is an intangible assets. Now, what is patents? Patents is right to exclude others from manufacturing or marketing an invention from a limited period. The time period is 20 years from filing your provisional patent application, and brands are built around patents. And the very good example would be Apple. If we talk about Apple, we have the brand as iPod, iPhone, iPads, then we have iMini. So patent is something for technology. It can be a product or a process. Now coming to trademarks. Trademarks are words, symbols, or devices, and it's protected by law. Like you can trademark a name, you can trademark a logo, a tagline. For example, like trademark identifies and distinguishes a specific product from others in the marketplace. From your competitors, when your consumers are coming to you, it's because of the brand name you have developed. And the brand name which you have developed means protection in law, so that not any third person can start a business next day and say that we associate ourselves with X brand. So you need to file a protection. Trademark identifies the source of origin of goods or services. It helps guarantee the quality of goods bearing the mark. As I said, a consumer is able to identify your product or service. It creates and maintains a demand for the product. In the case of Apple, since they have built around the brand and built around the patent technologies, when I say Apple, it's an iPod, iPhone, iPad, you name it, they do it. And definitely trademark can be used as a marketing tool to build your brand. Now, the amount of protection for trademark depends upon its distinctiveness. Like if you coin a name, like you can take a prefix, you can take a suffix, like Kodak. It's like they take the prefix from somewhere, suffix from somewhere, and definitely they can be distinctive mark also. It depends from business to business what kind of brand name you want your consumers to associate, and it will be better if you do a market research before launching a brand name, because it is the brand name which is going to take you forward, because your company will be known by the brand, not by you. Then coming to copyright, it's a legal protection to authors for original authorship. What can be copyrighted? It's a very important question for entrepreneurs who are in the software domain. Like software codes can be copyrighted, then books can be copyrighted, films and compositions are there. Right of author is safeguarded, and copyright, like there's a clear demarcation between copyright and patents. Copyright is not for ideas, procedures, or methods of operation or mathematical concept as such. As I said, copyright is for software code. So you need to understand what kind of IP is being generated in your business, as I said earlier. Because unless you don't understand what kind of IP protection you need, you won't be able to succeed in filing for the right kind of IP. Coming now to patents. Patent term is 20 years from filing, and all IP rights are territorial in nature. When I say territorial in nature, it means you have to file in each and every country where your business is. You cannot say, I file in India and I seek protection in US, or the other way around. I file in Japan, I want to seek protection in India. That's not there. You need to file in all the countries, whichever is your business goals are. If you are, say for example, you have a company in Singapore and you are seeking funding there, so definitely you need to protect your IP in Singapore before filing in India. Now let's talk about the patent requirements. Patent requirements, you need to fulfill these requirements before a patent is granted by the patent office. That is, it should be new. It should be useful. It should be solving some prior art problem which is already existing in that domain. It should not be obvious to a person skilled in the art. When I say a person skilled in the art, it means a person of that domain. The method should not be something which is already been devised by somebody else earlier. It should be something new. And while writing a patent application, you need to disclose the best method by which the patent will work. Scope and life of patents. This is very important. As an entrepreneur, as a startup, or as any technology company, you need to understand what that patent document talks about. Patent writing is a skillful thing, and the scope is defined by patent claims. When we talk about patent claims, that's the heart of the invention. That is what, like, whatever is written in your claims, you will be getting protection on that. So you need to make sure your patent claims are broad enough that covers everything possible which you can foresee in future your competitors might be doing and filing a patent in the same domain. And once the patent claims are written, it is supported by description and figures in the detailed description part. So when I talk about the scope for a patent, then what? Then it is published. Then once it is published, we need to file for request for examination. And once it is examined, the examiner issues office action response, which we need to respond. So once the patent is granted, it's not all. You need to file for the renewal fees. If you fail to file for the renewal fees, your patent will lapse and anybody is free to use that without your permission. Now, why patent is so important for a technology company? Patents is definitely important to investors because when a technology is developed and a patent is filed, so it's a negative monopoly right which you get to exclude others from performing the same thing without your consent. So you have an upper edge in the market. So that's why even the investors might be interested, like they might be interested in funding a technology company which owns some IP. It's definitely a very important asset. Secondly, it excludes the entry of competitors in the same domain. If your patent is granted, no second person in that country per se can work your invention without taking a permission from you or giving you a royalty. Thirdly, it develops investors' confidence that you are really willing yourself to sustain your business. And definitely establish a market credibility because once your brand is developed, you have your own trademarks, so trademark values a lot. And maximum license from another patent holder. In that case, you need to take that license, and you both can grow in the coming years. Definitely generates a license revenue stream. A very good example would be Skype was taken over by Microsoft. It was the intellectual asset which was valued 8.5 billion. So I think when you talk about IP, if IP is protected, and in the long run when acquisition is there, you cut a good deal. Now let's talk about the patent myths. Many a times we get clients and they say, okay, patent gives the right to use and practice the claim subject matter. But in reality, when I get a technology and people say it's novel, but what's the proof? It might be because, as we discussed in our earlier slides, patent is given for a new invention, something new which is not existing worldwide. So in reality, there could exist a broader patent. So a patent is not a defense to infringement of prior art. So what would be the strategy in this case is to timely conduct freedom to operate search. In other terms, we call it a clearance search or right to use search. And you should talk to your patent lawyer. He will conduct the search in that particular country and he'll give you the results. And if it's a straightforward case, you can then go with working in that technology. And you take opinion from a patent lawyer regarding the third-party patent guide before commencing manufacture, sale, use of potentially infringing process or product. A good example would be currently there are people are entering into this LED domain. So in this case, so whenever a new player wants to start a business, they are getting their freedom to operate searches conducted, because when we talk about LED technology, the LED technologies are also of many types. Now what I want to start manufacturing is of concern because all foreign companies are getting their IP protected in India because India is a big market. So you need to get your freedom to operate, clear and search well in advance if you think you might be infringing someone's patent. The startup companies, entrepreneurs, when they think like, okay, they want to file a patent, they'll just search on Google. And what comes? Okay, there's a worldwide patent, so they'll ask me the question, can I file a worldwide patent? I want an international patent. But in reality, there's nothing called as worldwide patent. It must be filed individually and separately in each country where protection is sought. As I said, patent rights are territorial in nature. So I would be discussing in the coming slides about WIPO and PCT, which is a different mechanism altogether, but it is not a granting authority whereby you can say I have been granted a worldwide patent. So I would, I just want to make sure like everybody, like if you are, planning to file a patent, so just clear your basics. There is nothing known as worldwide patent. And secondly, does international patent protection exist? As I said, international patent is something different, but the granting authority is not there. So filing before WIPO is part of IPR strategy, whereby you are increasing the time limit to enter in other countries. When I say time limit to enter in other countries is, if I file a patent application in India today, I have 12 months time to file in other countries. But if I don't have the funds, I would rather go for a PCT application or international application whereby I'm buying time from them. So WIPO publishes the patent application, but it is not a granting authority. So as an inventor, I should understand WIPO is not a granting authority. It's just you're buying time from them. I'd like to explain you this PCT timeline. PCT stands for Patent Cooperation Treaty, which India is also a member. So it's, say for example, I'll also talk about, before starting this, I'll talk about provisional patent application. Like if I have an idea today, but my idea is theoretical and I plan like in next 12 months, my idea would be in a workable condition, I'll go for a provisional patent application. So say for example, you file a provisional patent application on 0th month. That is your priority date, and you can, as I said earlier, you can file your application within 12 months in other countries. If you're not able to file the application in 12 months, you can file at WIPO. Once you file at WIPO, that is also has to be filed within 12 months. So once it is filed on the 16th month, ISR and ISA is issued. ISR is an international search report. We need to select a searching authority while filing at WIPO, and it depends. Like say for example, I would be filing in Europe if my technology is of that importance. So I'll select the authority as EPO. EPO is the European Patent Office. So once we have the ISA report, and many a times you have objections like claim this is not workable or you need to amend this, so you can file the amendments. But what I wanted to show you in the timeline is like you can enter in other countries in 30 or 31 months per se from priority date in other countries. Now what happens is, as I said, you're buying time. So if you see here, it's like you're not filing the application in 12 months, but you extended your time period till 30 months. So it gives you a good time to raise funds so that you can actually afford the patent attorneys or the lawyers in those countries to prosecute the applications. Now I'll talk about trademark and brands. People can do without patents, but you cannot do without trademark and brands, whether you're a startup entrepreneur or whether you have a business entity. And when people start recognizing you by a brand, so it's a source identifier for your goods and services. So having the right trademark ensures that the business is marketable and protectable. And again, like before filing for a trademark, or I would rather say from my experience, one should, before starting the business and coining a name, should conduct or should contact their lawyers, or they can themselves conduct a trademark clearance search to know if a similar trade name is existing. Because what happens is we just name something and we start a business, and all our marketing resources, advertisements is done, and one fine day we get a legal notice from other parties saying that we are infringing their trademark. So a trademark clearance search is very important for any business entity. And you can also Google up the names and see if such kind of name exists. Trademark can also be granted for unique domain name, so domain name can be also be protected by trademarks. If I talk about trademark registration in India, it's within 10 to 18 months from the date of filing, the trademark proceeds towards the grant stage and your trademark is registered. You get a certificate, but in the meantime, it might be objected or opposed by any third party. So once registered, it is valid for 10 years, and again there's a process of renewal. You need to renew it after every 10 years. Further renewals, if not filed, it will lead to abandonment. So you need to make sure if you have protected the IP, you pay your renewal fees in time. Now this is a very interesting, I would be discussing about what all I can be discussed till now. As a consumer, if I go to purchase a car, and if I say a Hyundai car, the Hyundai itself is a trademark logo. That's what the importance of brand is. Brand is very important from the user's perspective, and you should make sure that you protect your brand by filing trademarks. And then again, many times people say, I need design patent. In India, it's the aesthetic look of the design which can be protected under design registration. So per se, in this case, I would rather say the look of the car can be protected under industrial designs. And if I talk about the patent, maybe for the tires, the way the tubeless tires are made, They might be having a new manufacturing process for which one might file a patent. So as I said, as a business owner, I need to identify my IPs, and once I identify my IPs, I need to file for protection. Now, what are the IP strategies for startup? Now, this is a very important question from our startup entrepreneurs, and they have these questions always on their mind. Can I enter the market without infringing IP? Now, this is a tricky question to answer. Can I enter the market? As I said, you need to do your market research well in advance, identify your competition, identify your competitors, identify what is the existing competitive technologies in your domain, and say perhaps you have a technology for which you seek protection. What impact does your invention will have on the competitors and the other technologies? If you're able to differentiate between these two factors, I'm sure you will succeed in the long run having a successful IP portfolio with you. Now, I'm talking about patent scope. You should know your limits of the invention. As we discussed earlier, limits are defined in, when you talk about where the limit is defined, it is defined by the scope of the patent claims. So how broad claims have been granted by the patent office, what's the scope of the invention, how limited your invention is, and what has been granted. So the scope is very important. So what differentiates your invention from known competitive technologies? So when I say how it differentiates, if you're able to answer these questions, you understand how you are different from your competitors and why you are succeeding in the long run. When you talk about value propositions, say for example, I start a business venture in India. Now I want to go to foreign market. When I talk about foreign market, who are my customers in those markets? So as I said, any IP right is territorial in nature. You need to protect that IP right well in advance in the identified market. Now the question comes, is IP a business asset? Yes, definitely IP is a business asset for each and every technology. As a director of a company, as a startup entrepreneur, you need to identify that asset, capture that asset, and protect that asset by way of filing IP rights. Protect your intangible assets because it's going to increase your portfolio. It's going to increase your valuation of the portfolio. Now, this is a very interesting question, how to identify IP in your business. If I'm able to identify IP in my business, that's a differentiating factor. So, what all is needed? You need to identify the unique points and how you are different from your competitor. If you can map it out, that's where you will know my IP has been generated. My IP can be in terms of copyright, my IP can be in terms of branding. Even a single company can own multiple brands if they want to. And if they think that brand might be unique to their business and would be increasing their IP asset. And if, say for example, you're not able to make it out, how you're different from your competitor, you put yourself in his shoes and see what happens if your competitor identifies and knows your unique business selling proposition. I'm very sure after the webinar, if you just sit and, map these things out, you will identify your IP if you have it till now. So, as I said, identifying your IP is very important. And once you identify your IP, you need to file for protection. What is the key takeaway here? If you don't safeguard yourself, no relief will be sought. After you see your competitor or third person infringing your business, that will be too late. You need to take these measurements in advance. I'll just give a brief about ourselves. We are Tech Corp Legal LLP law firm based in New Delhi. We are working in two different verticals. That is, one is BioCorp Legal for bio-related services, and the other we have CyberCorp Legal for mobile apps and software-related services. And TechCorp International Consultant is a Singapore-based firm, and you can visit our website at techcorpgroup.com. And our new venture under that is techcorpcapital.com, where ideas, technology, and business intersect. Our bio-related services talks about pharmaceutical, biotechnology, and drug laws. CyberCorp Legal discusses about, and we help entrepreneurs, startups, technology companies with protecting the IP rights in mobile applications, social medias. And definitely patent is our forte. So I think after this webinar, these questions must have been answered. Like, I hope, and I'm hopeful that you will be able to identify IP develop in your business. Start valuing your IP. Your ideas and know-hows may be some of your most valuable assets. So you need to protect that and identify IP licensing opportunities in market. Our motto is for today, the takeaway would be protect your IP today before it's too late. And with this, I'll end my presentation. You can get in touch with me at my email ID. You can follow me on Twitter. You can see my About Me page, and I'm hopeful I'll receive some questions now. Over to Chandar.
Thank you, Ms. Prity. We'll start our QA session. Our first question is from Mr. Viren. He asks, suppose I have a product patent in bracket biotech. How do I do the valuation for out licensing? Any specific formulas to be used?
See, when we are talking about out licensing, you need to identify the market first. As I said, IP rights are territorial in nature. So once you identify the country, say for example, for biotech, Germany or European countries would be of interest. So you need to see the kind of biotech application you have with you, and you need to map up with the companies which are then in that country, and then you can take things forward from there.
Okay, our next question is from Ankit. He asks, should we patent or copyright software code?
See, software code per se is copyright, and the algorithm which is developed in that software, that can be protected by patents by, we need to see, because what kind of software algorithm he might have developed. So if we can add a hardware component to that, definitely both copyright and patent can be filed.
Okay. Our next question is from Mr. Ravi. He asks how IPR can contribute in higher education in management studies in India.
See, IPR is right now after 2005 when the Patent Act was amended. Things have changed. Things were not the same in India per se. And I would say if IPR is taught in the right manner, the budding entrepreneur will understand the value of IP. And at the beginning of the businesses, they'll file for the IP and they won't wait like somebody copies their idea and then they realize that they should have filed for the IP. So I think education of IP in colleges, in management, maybe I would rather say in colleges also IPR should be a subject whereby practical knowledge is given to them so that they can implement in their daily lives when they are going for a job or they are starting their own venture.
Okay, our next question is from Tejasvi. He asks, if I am a programmer, how can I copyright my code?
See, code word by word can be copyright under Copyright Act. There is a provision and you can go to the copyright website and you can see that. So the whole code can be filed as a corporate application, and you will be given a certificate from 15 to 18 months. It generally takes to generate the certificate for copyright, and the copyright office in India is in New Delhi only.
Okay. Our next question is from Bridal. He asks, can we protect business idea or way to do business on an established technology?
This is a tricky question. See, per se, business ideas are not patentable. But again, if you see the kind of patent applications granted by the patent office in India or across the globe, if you can add a hardware component, and as I said, the idea, maybe that business idea, if it is not existing till date and you can add a hardware component, you might, subject to terms and conditions, you might file for a patent application.
Okay. Our next question is from Varun. He says, is patent infringement law taken in India seriously?
Definitely. Definitely taken seriously. If you read the newspapers, like now and then judgment is coming. It's just that the party who he has to take it up seriously with the lawyers. Definitely it's on the rise. It's not that you're not getting the damages. You're getting the damages nowadays.
Our next question is from Mr. Azad. He says, is it true that if I have talked to investors about my idea or product, I cannot patent it after the interaction? In other words, should one always patent and then interact with the investors?
See, question I'll like to answer in two parts. One is like when you're talking to an investor for the first time, you are definitely signing some kind of NDA. And as I said, if you think your idea has potential, get a search done or do it yourself and file for a provisional patent application. The government fees is just 1,000 rupees. Why not, pay that 1,000 rupees, file for a provisional patent application and talk to investors. Your IP is secure, your idea is secure. Nobody can copy like that.
Okay, our next question again from Mrudul. It was actually during when you were talking about patent search. He says, is it that patent search does not cost us anything?
See, patent search, if you're doing on yourself, you're doing the patent search, it doesn't cost you anything. But if you hire the services of a patent lawyer or a patent expert, definitely that's going to cost you. There are particular databases to search, but at the same time, when a search is conducted by an expert, he is looking into many more things which an inventor or a startup entrepreneur doesn't, because since he doesn't know about those things, he generally doesn't see those things. Say, for example, we take into consideration IPC. IPC is International Patent Classification. So there are many integrities involved in a patent search. If you're doing it on your own, definitely it is free of cost. If you get it done, then it is a costly affair.
Okay, next question is from Ruchita. She says, can we market or make business on a patent if it is filed in some other country?
I think I made it clear in the webinar, like patent rights are territorial in nature. If you have not filed for a patent in a particular country and you're marketing your service in that country, no protection would be given. So wherever there is protection, there you can enforce your rights.
Next question is from Varun. Can we challenge a patent in a way that if we have thought about it and we have developed it first, but someone else has filed for the patents?
See, you can challenge it by way of patent opposition. You have the particular time period whereby government office gives you time period to file that, and definitely if something has been developed by you and in the stipulated time period, if you approach the patent office, it can be challenged.
Our next question is from Parul. She says, I have developed a mobile application. What type of IP is generated in mobile application domain?
Okay. I'll again answer this in two parts. we get a lot of queries because right now everybody is developing mobile apps. So definitely the software code can be protected under copyright law, and the algorithm, if novel, can be we can file for a patent application. The look, feel of the mobile app, the way the mobile app is working, the photograph, which the screenshots can be also again can be copyright. So they can be multiple copyright for the mobile apps depending upon the technology involved.
Okay. Our next question is from Bhavik. It says, can we patent the process as my idea is process oriented?
Yes, process can be patented.
Okay. Our next question is from Ankit. While copywriting a software code using online method, what all this do we have to upload?
See, copyright cannot be uploaded online. They are not working online. You need to submit a physical copy. The website is right now, copyright website doesn't, they do not take online applications. You have to submit physical copy.
Okay. Is there something called international trademark?
There's an international trademark treaty. There's a Madrid treaty by which just India became a part of it. You can file and they take care of your application in multiple countries.
Okay. Our next question is from Vimal. Says two questions actually he's asking. Number one, bearing in mind a startup with minimal resources with idea conceived in India, possible manufacturing in China versus selling in US, how should IPR be managed? And the question number two is, okay, you can answer, I can ask the question number two afterwards.
Can you just repeat the question again?
Bearing in mind a startup with minimal resources with idea conceived in India, possibly manufacturing in China and selling in US, how should IPR be managed?
Okay, in that case, you should start the IP process in India. And as I said, if money is of concern in the beginning, you can file for a provisional patent application, and you have a window of 12 months to file the complete application. And I think when you are in a business, you can raise the first round, the second round of funding in those 12 months. And once you have the funds with you, you can file the complete application in India, and then file corresponding application in China and US within the stipulated 12 months to take things forward.
Okay. Our next question is from Ankit. Can you tell something about Madrid Protocol and Madrid Agreement?
See, Madrid Protocol and this agreement, again, as we discussed earlier, it's a method by which you are filing multiple trademarks in the authority takes care of it, and you file it in multiple countries. It's a one-stop window, so it simplifies your process. You don't have to go in each particular country to file the application.
Okay. The next question is from Reshma. Says, as an artist, am I allowed to use the copyright C sign on my website, as I have noticed those from the US have a registration number and some do not? Is it mandatory to register? Would I get in trouble for using the C sign without registering my name?
See, the beauty of copyright is, like, the day you create it, you can write copyright. The thing why people file for copyright protection is, like, what happens is where the stakes are high, say for example in a film, stakes are very high, so they file for copyright protection, they get the certificate. So when they go in court of law, the copyright certificate acts as an evidence. So the day you develop something, or as an artist you develop something and you using a copyright C, it's absolutely fine, no issues.
Okay. Our next question is from Mridul again. What does it mean to file provisional patent application for 1000 rupees Does it mean a file say X idea but realize in next 12 months that X idea has moved to X and Y? Can I accommodate that in the application after that?
See, when I say you file for a provisional patent application, 1,000 rupees is the government fees. First thing. Secondly, if your idea is X and next 6 months is Y, you can file an application, and whatever application details you're filing, you have to file it in the 12 months window. Maybe many times what happens is people are developing ideas on a quarterly basis, so they file 2 or 3 applications in that window. So in the when the 12 months finishes, maybe one application is having 3 priority dates, and whatever is being disclosed on particular date will get protection from that particular date itself.
Okay, now we will take another 2 questions. Our next question is from Mr. Vimal again. His question is there any government support for SMEs in patent search in various target countries or patent processes?
See, government, they definitely provide the patent search engine. If you Google it out, you'll definitely know it. Per se, they're not giving any funding for conducting a patent search. It is available. You can conduct the searches in those countries, or if you look at their respective websites.
Okay. Our last question is from Gargi. She asks, how do I manage IPR for a clothing line, like for the brand name, manufacturing process or delivery process?
See, one thing is definitely the brand name for which she can file protection. And again, in clothing line, if you have multiple things, say for example, they can be a particular brand. I'll take an example of Anita Dongre. So when I talk about Anita Dongre, she has bifurcated her brand. Like you have and you have Global Desi and Anita Dongre per se, and definitely she is targeting different segments. So you need to segment your business, and one business, as I earlier said, can have multiple brands. It's the way you do the branding of your business. This is one part. The second part would be if you're talking about the processes. If you can, as we were talking about competitors, if you can, you jot down your points and you can make a booklet. This is because of which I'm different from my competitor, and these are the processes because of which I'm able to succeed. You can file for a copyright in that case. And if innovation is there, or there's a particular technology by which you are manufacturing your clothes, then that can, in some instances, one can file for patents also.
Here we end our Q&A session. Thank you very much, Ms. Prity, for that interesting session. And thank to all our attendees for participating in the webinar. We are glad that questions kept on coming, but due to lack of time, we are unable to answer all. Please do send in your feedback or suggestions to us at eclub@nenglobal.org. Also, if you found the session interesting, feel free to blog or post about it. The recorded version of the webinar will be available soon on our website eclub.online.org. Join us for our next webinar in the month of June 5th. Till then, goodbye and thank you very much for once again.